Welcome everyone. Thank you so much for your registration for the Did You Know series on immigration law for community workers. This is a New South Wales Legal Aid webinar, Wednesday, October the 2nd. My name's Teresa Kelly and I work for the Respect at Work Legal Service at Legal Aid New South Wales. I'm here with Josh Strutt from the Immigration Rights and Advice Centre, who will actually be presenting this webinar. Before we begin, we would like to acknowledge the traditional owners of the lands on which we are broadcasting today. I'm broadcasting from the land of the Gumbaynggirr people, and we pay our respects to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. As a reminder, this presentation is intended for general information only and cannot be relied on as legal advice. The information is accurate at the time of broadcasting, but may have changed if you're watching the recording at a later date. If you need legal help about a particular situation, start with our team at Law Access New South Wales via web chat or at www.legalaid.nsw.gov.au or call 1300 888 523. Our presenter today is Josh Strutt. Josh is the CEO and Principal Solicitor of the Immigration Advice and Rights Centre. Josh has more than 10 years' experience working as a lawyer in both commercial and not-for-profit settings. He has extensive experience in immigration law, including assisting with family visas and family reunion, refugee and humanitarian visas, protection visas, and skilled and student visas. He has represented and advocated for clients with both the Department of Home Affairs and in court at both merits and judicial review stages. Josh is a published author on immigration law, having written several chapters of the Immigration Kit, 10th edition, including the chapters on partner relationships, bridging visas, and New Zealand citizens. I'll now hand over to your presenter, Josh Strutt from the Immigration Advice and Rights Centre. Thank you.
Thanks, Teresa, and thank you everyone for attending today. It's a great privilege to be here and to be presenting on this very important topic with you. I will just share my screen so I can get the slides up. And then hopefully everyone can see my slides. As Teresa said, my name's Josh. I'm the CEO and Principal Solicitor at the Immigration Advice and Rights Centre. I'm here today to talk about, give a brief overview about immigration law generally, which is quite difficult to do, and then maybe dive into some more relevant issues around some recent reforms, in particular around the workplace justice visa and around sort of some protections against visa cancellation. Before I dive in, I'd like to acknowledge that we meet on Aboriginal land and pay our respects to the traditional owners of this country and elders past and present. And I'd also like to extend my respect to any Aboriginal and Torres Strait Islander people present today, and in doing so recognise our own heritage as migrants to this land. As Teresa already said, this is there's a disclaimer on this presentation. Lots of good care and diligence has been given to this presentation by me, but please don't rely on it for legal advice. As a lot of you in this room may know, what is true today in immigration law or even this morning in immigration law may not be true this afternoon or tomorrow. That's what makes it so interesting, but also so terrifying. So please don't rely on this for advice. Please seek out immigration advice if you do need immigration assistance. Just a little bit about IARC. So we're a community legal centre that's operating throughout New South Wales. We're based in Sydney. We have been operating for over 35 years. We provide free legal advice and assistance on all immigration, refugee and citizenship matters. Everyone who works at IARC, everyone who gives advice at IARC are lawyers. So the information is protected by privilege. This is really important, especially in immigration law, because there are powers under the Act that can compel, for example, migration agents to give over information about possible unlawful non-citizens. So I think it's really important that people go to, especially people who are in vulnerable situations, those people on visas or who have uncertain visa status, that they seek advice from a legal representative so that information is protected. We also do conduct community legal education, which is what I'm doing here today. And we also produce resources such as fact sheets. We have a fact sheet on our website, a new one around the workplace justice visa, which you can easily access on our website, which the details are on the bottom dot point of this slide. We also run a program called Visa Assist for union members. And this is run in partnership with Unions New South Wales. This project was born many years ago, probably 5-6 years ago now, but I think the idea about it came even longer before then. And basically what was happening is that unions were going to work sites, talking to people, realizing that they were being underpaid or suffering other forms of exploitation in their workplace, and talking to people and saying, we can help you with this. We can, you're being underpaid, or you're not working in safe conditions. We can help you enforce your rights. And the first question out of everyone's mouth that they talked to, or the majority of people, was like, yes, but what about my visa? And that became a huge issue and a huge barrier to people seeking assistance. And so the unions sort of came to us and said, would you be willing to help us with that aspect of the work? We think it's a huge barrier to people enforcing their workplace rights in the workplace. And we, of course, said yes. That's exactly what we stand for as well. We want to provide free and credible immigration advice and assistance to people, especially people who are experiencing vulnerability. And then over the years, the project has grown. So I think currently we've assisted over 1,500 migrant workers over the last 5 years, not 500 years. Every year on year it grows and grows. I think last year alone we assisted 500 migrant workers, which is a huge number and a huge testament to the success of the project. In order to access that project, people need to join their union, but they can join the union on the same day and access the Visa Assist service from there. So it's a really, really great service, and I encourage people that if they are facing workplace issues and they are on a visa to talk to their union, join the union, and get access to the Visa Assist service. And I just have our website address down there, just if you want to access and have a look around. So today, I want to cover off quite a few topics, but I'll try to keep it short and sharp and simple as possible. So I want to start with a little bit of an overview of the visa system. I think it's important for me to start a few steps back just so that you understand sort of how the system works. And also when I start using certain visa lingo, it doesn't, go over everyone's head, or people don't, eyes don't glaze over because I'm using too much immigration terms. I've tried to keep it as light touch as possible, but I think it's important to sort of know how certain reforms or certain changes in immigration law operate in the bigger scheme of the system. Then I'm going to talk about some of the visa changes for migrant workers, so around the workplace justice visa in particular and the cancellation protections. I've then been asked to talk a little bit about visas and domestic violence, so where those two issues overlap and what is available to support temporary visa holders or people with an uncertain visa status. And then I want to talk a little bit more about where to get help for people, where they can access, how they can access IARC in particular, and then also how to access Visa Assist as well, so that people know how to access it, where to go, and what to ask for. These are sort of slides that sort of how I sort of think about the visa system, and I hope that it helps you understand it. So there are different kinds of visas within the visa system. So there are what people call generally temporary visas. So these are visas that have an end date. They can be like the PALM visas, the 403 visas. They can even be the visas that New Zealand citizens hold at the moment, the 444s, although they're a bit more complicated because they don't have an end date, but they're still classified as temporary visas. They can be what's known as a 482 visa, so an employer-sponsored visa. They have an end date. So it's really any visa that's not a permanent visa, and it generally has an end date attached to it as well. Then there's permanent visas. So there's not just one permanent visa. It's also often referred to as permanent residency. And I think often there's a lot of confusion in the community that people go, I've got permanent residency, or I'm on the permanent visa. And often we find that people actually have applied for a permanent visa and they haven't yet been granted that, or their decision hasn't yet been made on that permanent visa application. Or people sort of think that there's only one kind of permanent visa or permanent residency. There's multiple different kinds of permanent visas, and it depends on the pathway you take to get there. So there are skilled visa pathways to permanent residency. So people who might be employer sponsored might have pathways to permanent residency if their employer nominates them for permanent residency. People might apply for put an expression of interest in for a permanent visa through various skilled processes as well. There's a new Pacific Engagement Visa, which I think only came out this year, where people put their name into a ballot. And then I think they're drawing out 3,000 names a year from various Pacific Island countries. And then if they have a job offer in Australia, they can then be eligible for permanent visas that way. There are family ones as well. If you're you've got an Australian citizen partner, people can get permanent visas that way. So there's multiple different kinds of permanent visas. Generally, they have very limited conditions attached to them, but it sort of depends on what permanent visa you hold. So it's really important that even when people are permanent visa holders, they understand that there can be conditions attached. They're not usually that strenuous, but they can be. And the other thing is also important to know that even though it is a permanent visa, in some ways it's only in name only. It doesn't generally have an end date. However, having said that, there are what is known as travel facilities. So generally, once you get a permanent visa, you only have 5 years to travel on that visa, and then you need to apply for another permanent visa. If people leave after that travel facility has expired, that 5-year period, the permanent visa ceases when they leave Australia, and it can create all kinds of headaches for people. The other thing as well is that permanent visas can be cancelled. So they can be cancelled most commonly from what we see for character issues. So people have committed offences in Australia or overseas, and that leads to their permanent visa being cancelled. There are other issues where people might have lied on their visa application, and that can also lead to permanent visas being cancelled later. There's also a lot of lingo around substantive visas and bridging visas. Substantive visa basically incorporates temporary and permanent visas. It's the easiest way to think about it is it's almost any visa except for a bridging visa. There are things known as criminal justice visas and enforcement visas, which are very rare, and they're also not substantive visas. But I think generally, if you can think of a substantive visa as anything that's not a bridging visa, you're generally quite safe. And bridging visas are probably quite commonly seen in the community, especially in regional communities. We see a lot of clients who are on potentially bridging visa E's or bridging visa A's, waiting for visas to be decided, or might be waiting for appeals. Bridging visas, in my mind, the best way I can describe them, or the way I think about them, is to think about them as waiting visas. So you're waiting for something to happen. And so that can be you're waiting for a visa to be granted or a decision to be made on a visa. You're waiting for an appeal of a visa decision. You're waiting for the minister to make a decision about intervening in your case because you've had a visa refused in the past. Or you might be waiting to return home. Sometimes people generally can apply for bridging visas to make arrangements to depart Australia because they're unlawful. And so people might apply for a bridging visa E on departure grounds in order to make arrangements to leave Australia. It's very difficult and unwise to try to leave Australia without a bridging visa or without a substantive visa, because people can be detained at the airport, and they should get immigration advice before they think about leaving Australia if they do have an uncertain visa status. There's also different kinds of bridging visas, so that also makes it a little bit more complicated. I think there's 7 different kinds of bridging visas, and the bridging visa a person gets is dependent on their situation. So if they've applied for another visa while they held a substantive visa, they might get what's known as a bridging visa A, which is quite a favorable bridging visa. Whereas if they've been unlawful for a period of time, and depending on why they apply for a bridging visa, they might get a bridging visa C or even a bridging visa E. And bridging visa E's are usually referred to as one of the less favorable ones, probably one of the worst bridging visas to have, because they often have lots of conditions attached to them, such as no work, no study. You can't travel outside Australia on a bridging visa E without, because it will cease. There's lots of issues around bridging visa E's out there. I'd also probably say there's a bit of a stigma attached to bridging visas generally as well. And I do talk to a lot of clients who struggle to find employment because they hold a bridging visa, and employers are nervous to employ people on bridging visas because they don't know what they end and when they end, and they don't know what rights are on those visas. So yeah, they're very complicated visas, but I suggest people just get immigration advice about their visa status first and foremost. In terms of the visa system, so this is sort of, again, the way that I think about them and the different kinds of visas that exist out there. So there's family visas, so there's partner visa if you're in a relationship with an Australian citizen or permanent resident. You might be eligible for a partner visa. There's child visas as well, and there's parent visas as well. In terms of, parent visas can take a long time to process. As a heads up, the waiting periods for those can be quite long, or they can be quite expensive. Humanitarian visas as well, so people who are in Australia and then can't return to their home country because of fears of persecution, then they can apply for a protection visa in Australia to stay in Australia, so they don't have to go back to their home country. And there's also offshore humanitarian visas, so people who might be overseas and make an application to come to Australia on humanitarian grounds. There's skilled visas, which I touched on briefly before, but there's many different kinds of those. There's the employer-sponsored, the skilled independent, temporary work visas, for example, the PALM visa, the 403 visa, that's the subclass of visa. There's a global talent visa as well, and there's business visas. Actually, business visas should be deleted. I think they've closed down recently, so business visas are no longer a thing. The government sort of shut down that program. There's also student visas as well. So you have sort of the classic subclass 500 visa, which basically people enroll in a registered course in Australia and can apply for a student visa. They've been facing a lot of scrutiny in the media lately, especially due to the high refusal rates at the moment, because the government has changed the policy around student visas and how to be eligible for student visas and what it means to be a genuine student and passing the genuine student test. There's also training visas where people are often sponsored to train in a particular place. Then there's visitor visas as well. So you get the working holiday maker program or working holiday visas. And they're the ones that we've seen where people come from various lists of countries like the UK or some other European countries, or I think the United States as well might be on the list. And they can come here and sort of stay for a year and work part of that time in a regional area. I think the UK citizens are now exempt from having to do that regional work, but generally the regional work is to make people eligible for the next working holiday visa. So unless they do the regional work, they won't be eligible for the next visa. Visitor visas as well. So people want to come here for a holiday or to visit family, they might apply for a visitor visa. And then there's medical treatment visas. So people might not be able to leave Australia because they need to undergo medical treatment in Australia. But these are sort of the broad 5 categories in which you'll find most visas to be substantive visas to be held in. In terms of the visa changes, there are 2 key changes I want to talk a bit more today. I want to talk about the new temporary workplace justice visa and the protections against visa cancellation. I've put an asterisk against protections because I think it's a bit misleading. I think what we originally thought it might be versus what it is today in law and does not provide an absolute protection against visa cancellation, but I'll talk a bit about that later. Just maybe some context around these visa changes. So these ideas were born similar to the origin, I guess, of visa assist, where people were very scared to speak out about unscrupulous employers because they feared reprisal. They feared jeopardizing their visa status and their future in Australia. And so part of what our campaign really was behind this, or our idea behind this, was that you're not going to have people coming forward and speaking out against their employer or leaving employers or identifying employers without shoring up their visa status first. And so having looked at the Act and looked at the regs and looking at the way the visa system works, there were a few suggestions thrown up. But one big issue was that people sort of come towards the end of their visa, and we've had a lot of clients along these lines, are promised for years and endure terrible treatment from their employer that they will be sponsored again for permanent residency if they just stick it out. And that's what they constantly think. And then right near sort of the end of their visa, their employer pulls the rug from underneath them and says, actually, I'm not going to sponsor you for another visa. Good luck, goodbye. Sorry, that we're done with you. And there was really nothing that person could do. And they've endured possibly years of underpayments, years of unsafe work environments, bullying, sexual harassment, many things. And so we were like, these people are really at the end, of their visa. They feel like they have to go home. They feel like they don't have any rights, and they have no ability to stay in Australia to bring a claim against their employer. And that's where the idea of the workplace justice visa came. And it's really, as the department have characterized it, as a visa of last resort. It's a visa that if you're coming towards the end of your current visa, or your current visa has just expired, it allows you to stay in Australia to then bring a claim against your employer, so that it gives someone the ability to bring those claims and to stay here, and gives them sort of, I guess, effectively access to people who might be able to assist with that, which I will talk about a bit later on. So that was one mechanism that we said needed to be introduced, so that people towards the end of their visa felt like they could speak out, they could bring an action against their employer. Having said that, there's also the whole visa framework, and there's also benefits of not moving from visa to visa and chopping and changing a lot. And that's because often a lot of visas offer pathways to permanent residency, or they might offer pathways to different visas, or or a next iteration of the same visa. And so having that in mind, there also needs to be protections against visa cancellation. So what we also wanted to see was that very much in the student visa context, where people were working in excess of their, at that time, 20 hours a week, but now it's 24 hours a week, and were being paid considerably less than minimum wage, and being told that they need to work extra hours to make up for certain things and to even make ends meet and to live in Australia. They were then, working in excess of those conditions, and probably in excess of those hours, and probably in really horrible conditions as well. I think the classic example that that people are aware of is this 7-Eleven scandal many years ago, where people were working, a lot of student visa holders working in excess of their hours, being paid, but then being forced to go to an ATM, withdraw their pay and give it back to their employer. And all those people were very scared to speak up or say anything because they were scared that their visa would be cancelled. And the unfortunate reality is there are powers in the Act, and there are at that time, there were no real protections. It's a discretionary power, but we have seen it exercised in a lot of cases where we thought that the power should not have been exercised because of some sort of workplace exploitation or other compassionate circumstances. So we sort of said that we need to have something that protects people against visa cancellation, so they can stay in Australia. They know that they can speak out against their employer, provide evidence to the department, or do something to ensure that actually, no, I can stay on this visa. I don't have to be treated like this. I don't have to fear for my future. And so that's where this idea came from, because we found that now that these are in place, that more people are coming out and approaching our service and having conversations with us than before, because they know that their visa will hopefully will be okay. However, I will talk about that a bit later. There's another key change which I haven't added in here, just to keep it a bit simpler. But there's a lot of the employer-sponsored visas have ties to their employer. So basically what that means is they're sponsored by their employer and they have to stay with their employer. And that's just basically a condition of the visa. If they leave their employer, they would have to find a new sponsor, and they usually only had 60 or 90 days to do it, which in our experience is way too short, and people just felt trapped by their employer and wanted to stay and, and just basically put up with whatever conditions they could bear until the end of their visa, because they didn't want to jeopardize that visa. They also, again, as I said before, there was a promise of permanent residency or some other future sponsorship, and they didn't want to jeopardize that opportunity either. And a lot of the eligibility for future employer-sponsored permanent residency requires the employer to sort of either say, yes, I want to nominate you, and also requires some level of 2 years working with that employer, at that time even 3 years working with the same employer. So there's a lot of hooks in the visa holder to stay with their employer, and they were huge issues why people weren't speaking out and basically saying, I'm going to leave. What the government has done now is they've introduced what's known as portability within this program. And so people actually now have 180 days to find a new sponsor. And in those 180 days, they can work for whoever they want to work for. So it's a huge improvement, and we find actually a lot of the people approaching our service are eligible for the portability and not necessarily the workplace justice visa or the protections against visa cancellation. And I think that's probably a positive thing, because it keeps them on hopefully a positive pathway to stay in Australia. So that's sort of the 2 or 3 key changes, but I'll dive in now to the workplace justice visa and just provide a little bit more information around these changes. So the workplace justice visa is a temporary visa, and it basically just allows temporary visa holders or recent temporary visa holders to stay in Australia to take legal action if they have been exploited at work. In order to be eligible for the visa, your visa has to either be within 28 days of visa expiry, so it needs to be, towards the end of your visa period, or your visa needs to have expired no more than 28 days ago. So there's about a 56-day period there where people can apply. Having said that, I think people shouldn't wait till the last 28 days. If possible, they should try to seek advice earlier, and then possibly be within that 28-day period when they decide to apply, if they need to, a workplace justice visa. What workplace exploitation means is there's legislation around this, or what's known in our context a legislative instrument, which sets out what can constitute workplace exploitation. But that can be things like underpayments, bullying, sexual harassment, discrimination, unfair dismissal. There's many other examples in there, but they're just some of the ones that we pulled out that we've seen quite commonly. But they're some of the examples that we do see. But how do you, access this visa? There's a bit of a process, and there's a bit of a mechanism in order to go through this. But basically what you need to do is a person needs to go have their workplace claim certified by an accredited third party first. So there is a list as well. I think it's on the department website, but it's also in what's a legislative instrument as well, which basically sets out that certain unions and community legal centres can sign off on the workplace claim. And basically what that means is this person needs to go in with their evidence to either a CLC or a union and say, this is what I've experienced. Then the certifier needs to look at the available evidence, look at what's being said, and basically make assessment whether this claim has prima facie merits, or basically has some sort of claim. It doesn't need to be like, yes, this will be 100% success, but then there needs to be something there and some action that can be taken in response to that workplace exploitation. And so that's sort of the role of that third party, accredited third party, and they need to provide a stat deck in support of that. And the stat deck has to contain certain information around, the visa holders' details, the employer's details, and sort of what the exploitation has been experienced. Then what happens is, or the process that we sort of have is, we firstly assess people for the eligibility of the visa. So that's things like, do they have health insurance or can they get health insurance? They'll need that. They'll need to show that they can support themselves in Australia, meet certain health and character criteria. So if there's a health condition, that might mean they don't meet the health criteria. That could be an issue. Or if there's a character issue, so for example, there's been some criminal offending, that might also affect the ability for people to get the visa as well. The biggest one that we see is that people just aren't within that 28-day eligibility period. So people are coming in saying, I want to apply for a workplace justice visa, but they're on an employed sponsor visa that has 2 years left to run. And so we then tell them about the portability rights and that they're not eligible for a workplace justice visa, nor do they need one because they can leave and they have, 6 months to find another sponsor and can work wherever they want. So those are sort of the things that we check for. And so as step one, we sort of filter out people and say, well, yes, you're eligible, or no, you're not, or you don't need a certification. And then we send them to the accredited third party to have them assess, because we're not employment lawyers or workplace lawyers. We don't deal with that at all. We just do immigration law. And then if they assess that they do need a certification or they're eligible for a certification, the third parties certify, and then they come back to us and we assist them with either with this visa application. But I think the biggest thing with these is it's the immigration system, as I showed you before, is quite complex. So it's not just about applying for a workplace justice visa. It's also about what's in the client's best interest in terms of their visa or immigration journey. And so sometimes maybe a workplace justice visa may not be the best visa for them, and they might actually be eligible for another visa, which may maintain their pathway to permanent residency. So it's a very complex conversation. And so we really recommend that people get some immigration law advice around this issue, because what we've seen in the past is people, well-intentioned, obviously apply for certain things, and then it really ruins sort of their future visa options, or at that point in time, if they got different advice, their visa journey might have looked a lot different. So I can't stress enough that it's really important to get immigration advice in relation to these issues or anything that involves a visa. The other things I should add is that it is free to apply for, so there's no visa application charge, is what it's known as. So that's really good, and it has unlimited work rights, so people can work as much as they want on this visa as well. So that's two really positive things that we pushed for too. The general sort of length of time that they can be granted for it can be from 6 to 12 months, and it depends on the certification provided and what the department thinks at the time. So yeah, they're very short-term visas, but you can apply for it again if that workplace issue isn't resolved, and they can get another certification to demonstrate that. And part of the condition on this visa is that they need to continue to progress their matter. So it can't be, I've applied for it and then I don't progress my workplace matter at all. There's an obligation on the visa holder to then progress their workplace matter. In terms of the protections against visa cancellation, so these are applicable where a visa may be cancelled due to a breach of work-related visa condition or another visa condition. So the idea here, which was the student visa example I gave before, is where people, might be working in excess of their 40-hour fortnights, or 48-hour fortnight, sorry, now, or may have left their employer. I know in the PALM scheme or the 483 visas, I know that people often abscond from their employer or leave their employer when they're treated really horribly in their workplace, and that can often trigger visa cancellation unless they find another sponsor. So those are the sort of situations where this is anticipated, that we would be able to provide some sort of certification, or an employment lawyer would be able to basically stave off any risk of visa cancellation. They have two they have two different types of visa cancellation protection. So they've got one that's called non-discretionary. So that's supposed to be the absolute guarantee that the visa won't be cancelled. And then they have what's known as the discretionary discretionary sort of non-cancellation provisions. In terms of the non-discretionary, it's, in my opinion, probably non-discretionary only in name. And the reason I say that is because the Act, the associated regs still require the minister to be satisfied of certain things. So even with a certification, the minister still needs to be independently satisfied of certain issues. And so I think when you add that sort of additional element to these things, what may be called a non-discretionary provision is really discretionary in reality. So I think that's a bit of a misconception. I mean, we'll wait and see how it plays out. This is a pilot, so we don't, maybe I'm overstating it, but I think looking at the regs alone or regulations alone, I'm dubious whether it is non-discretionary. But all you really need to know for the purpose of this is there are certain provisions that have been added in to sort of bolster or to further protect migrant workers from having their visas cancelled. So what this needs, similar to the workplace justice visa, is a certification from an accredited third party. There's a list of unions and CLCs, community legal centres online. I think that list will continue to grow over the next years or two as more and more people become accredited. The really good thing about the fact that there is an accredited third party list, and something I should have mentioned earlier, is there is a Fair Work Ombudsman who's on there, but outside of that, they're all non-government organisations. So I think the really positive thing is that people can go to an organisation that is not connected to the government and feel safe in disclosing certain information to them, knowing that it's not going to be filtered back without their consent. And I think that's a really important thing, and has led to a lot more people coming forward and talking about the treatment they have endured in their workplace. There is also possibly a requirement, depending on what protections you're looking at, that they need to have been subject to workplace exploitation within the last 12 months. So that's just something to watch out for. It's better to get certification sooner rather than later. And as I said before, it may not be a complete protection against visa cancellation. It's important people seek legal advice and understand the risks associated with these provisions. I think there needs to be some careful planning and careful thought put into when people provide certification and when they don't, and about their visa journey and their immigration history and which ways they're heading, just to ensure that they're not jeopardizing themselves unintentionally. In terms of visas and domestic violence, just changing gears for a moment, it's really, the intersect can be quite complicated, and it can vary depending on the visa someone holds or has applied for. Domestic violence can mean that people may be still eligible for the same visa, which I'll talk about later, but it can also mean that visas could be cancelled or applications refused. And for example, we've had clients who are dependent on their partner's application and have experienced DV, and then their partner has reported them to the department to say they're no longer with me, when they've left their abusive sponsor. And then the department have written to the dependent visa holder and said, we're going to cancel your visa. They have the ability to cancel it. Tell us why we shouldn't cancel your visa. You have 5 business days. And so it's quite an intense process, and the implications of DV on visas can be, very complex. And so again, we encourage people to get immigration advice, but I think it's important for people to be aware of the risks and the intersect between the issue. Unfortunately, there is no domestic violence visa or compassionate visa. It is a question we get a lot. It is something we're advocating for, something sort of in the same spirit, I guess, as the workplace justice visa, because we think it's important for people to have the ability to step off their sponsor's visa and be able to be independent from them, and ensure that they can then set themselves up independently in Australia rather than being worried about the risk of visa cancellation forever, or staying in an abusive relationship because they think their visa will be cancelled. As I mentioned before, there are pathways to permanent residency potentially, depending on the visa you hold. It's very few visas. It's really only mostly family visas, like a partner visa or child visas. There's what's known as a family violence provisions. And basically the way it works is that if someone has applied, for example, for a partner visa, and then after they've applied, for that partner visa, or while the relationship's actually ongoing, if they experience DV and the relationship ends, then they can rely what is known as the family violence provisions. And what that actually means is that people don't have to stay in the relationships to still be eligible for the partner visa. They can provide certain evidence to support a claim of family violence and basically say, no, I'm no longer with this person, but I've experienced family violence, and therefore I should still be eligible for the partner visa. And there are provisions for that set out in the regulations. Another one is there is also what's known as a child of the relationship provision. So if people have a child of the relationship and then the relationship breaks down, they may still be eligible for the partner visa as well, because there is a child of that relationship. The other issue that I thought might be worth raising as well, that domestic violence may also be relevant to an application for a protection visa. So if people have experienced violence in their home country, or domestic violence in their home country, it may be, depending on the country they're from, a protection claim, and it might be something that they might want to raise if they want to apply for a protection visa to stay in Australia. So that's also something that's really important. We've also had people who've come here and been and have their sponsor or their partner be violent towards them, but their partner is also a national of their country, or is a national of their country, their home country, and then they fear going back and the reprisals they will face if they were to go back to their home country. So that is another way that domestic violence may be relevant to a visa application, is where we're looking at protection visas. Again, I feel like all of my slides enter this, but it's just such a complex process, and it's just really important that people get immigration advice around these issues, so that they know what impact sort of external circumstances may have on their visa applications or their current visa. In terms of getting help, so the best way to contact us if people do need immigration assistance is to fill in an online inquiry or referral form on our website. It's an inquiry if it's from the person. There's a Get Help button, and they can fill in the form there. It's actually a bit of a chatbot that they can talk to and gets all the relevant information out for us. There's also an online referral form as well. So if you're referring someone to our service, you're a service provider, please use the referral form, and we can take it from there. People can also call IARC on the phone number there between 10 a.m. to 12 p.m. and 2 p.m. to 4 p.m. Monday to Friday. I will give you a warning that the phone lines are quite busy. We have a lot of volunteers and some admin support as well, but even then our phone lines get quite busy and we can't answer all the phone calls. So the best way to often contact us is through one of the web forms. And then you can also send an email to info@iarc.org.au if all else fails. In terms of accessing visa assist, we think in terms of visa assist, I thought I'd put this up here because that service might be good for people who are experiencing workplace exploitation, because the union, this service can both assist with both the workplace issue and the immigration issue. So what happens basically is that people, there's a join a union link there, where people can work out, or Unions New South Wales can work out what's the relevant union for people to join. But in short, once they join their union, in terms of the immigration advice they can join today and get advice tomorrow. Like, there is no waiting periods. I'm not sure about the workplace issues. It's not my domain, but I know for sure, given that we run Visa Assist, that if people join their union, they can get advice the same day from us. depending on waiting periods, but they can at least access or put a referral into our service on the same day. And really, it's a pretty simple process. The member doesn't need to put through a referral themselves. The person that needs to put through a referral is generally the union organizer or whoever's working at the union. They will help with the form, send it through to us. It gets received to us instantly, and then we process it from there. That was all I really wanted to talk about today. I know it was a lot of information, but hopefully it provides some sort of oversight about the visa system and some of the relevant changes. There are a lot of changes happening at the moment as well, especially over the last 12 to 24 months. There's been a huge amount of changes in the immigration system. I've barely sort of scratched the surface of those changes, but I'm hopeful that some of this information was helpful, and I'm always open to conversations or chats or further CLE on any of those issues. So thank you so much for having me, and thank you for being here.
Thank you very much, Josh. That was really informative. I know that, you know, if I have any questions about immigration, the IARC is going to be the first place that I make a call. I'd just like to thank you all for participating in today's webinar, and just remind you all that you will receive an email with an evaluation survey, and we'd really appreciate your feedback. You'll also receive an email with the answers from the Q&A section from today's webinar. And just to remind you that this series has been developed in response to community needs as they have been reported to us, and that there are 4 more webinars in this series, which include Safe Work New South Wales, which will talk about worker rights and obligations for PALM and migrant workers, employment law, workplace sexual harassment and discrimination, local legal aid officers and work development orders, and the Australian Human Rights Commission. Again, if you need legal help in a particular situation, give us a call through Law Access on 1300 888 529 or contact IARC on 02 8234 0700. Thank you all for attending today, and hopefully we'll see you next week. Thank you.